The Bureau of Alcohol, Tobacco, Firearms, and Explosives is focused on getting illegal guns off the streets.
Those selector switch allow you to have fully automatic, 3-round burst, or semi-automatic.
The people on the street that are getting these firearms pointed at them, they're not safe for the people who are using the firearm.
The ATF says it still has lots of work to do in order to get these illegal guns off the streets.
An update on the ongoing ATF litigation over pistol braces and the nationwide injunction against the brace rule. The ATF is now arguing that all of these lawsuits are unconstitutional because they would force you to avoid paying taxes.
The ruling leaves in place a federal law requiring the registration of silencers.
Tyrants disarm the people they intend to oppress. Those are the facts.
Gun enthusiasts hope lawmakers will pull the trigger and lift the ban on silencers.
Suppressor freedom lawsuit. A major legal dispute in the arms world centers on the suppressor freedom lawsuit, which aims to overturn laws prohibiting suppressors, devices made to muffle arm fire. Suppressors are legal and commonly used in 42 states. However, there are prohibitions on their sale and possession in several states, Illinois included. In addition to defending the right to bear arms, these cases aim to overturn the laws that restrict legitimate arm ownership. The federal district court in Illinois is experiencing agitation over the cases of Morris v. Raoul and Anderson v. Rule, which contend that these prohibitions violate the Second Amendment. They are establishing a precedent that may open the door for comparable challenges in other jurisdictions where these useful devices are prohibited, so their concerns go beyond suppressors. They want to convey, hey, just because we're in Illinois doesn't mean we shouldn't have the same rights as folks in other states. Things get more interesting when we get into the specifics of these cases. They are contesting the fundamental basis of these prohibitions, claiming that they violate the Second Amendment. Look, suppressors are everyday tools, not some crazy dangerous contraptions, they're saying. Therefore, why are they prohibited? It is hoped that these lawsuits would act as a warning. These are campaigns for justice and rights, not just for the law. Their goal is to bring attention to these restrictions, which appear a little out of date in a world when most states don't seem to mind people owning suppressors. The argument that suppressors shouldn't have the same Second Amendment protections as weapons is made in Illinois. They're trying to be tough by saying that these devices that reduce noise don't quite qualify as arms. They contend that suppressors are not the genuine thing, but rather more of an accessory. Their entire argument rests on the premise that suppressors are not protected by the Second Amendment, since they are not actual arm owners.
Was to ask them a specific question of what type of firearm were you issued when you were deployed.
The Bureau of Alcohol, Tobacco, Firearms, and Explosives is focused on getting illegal guns off the streets.
Gun owners, listen up. If you don't take action, you could be charged with a felony.
Our neighbors to the east and west allow silencers.
Why do we have guns? Why do we have the Second Amendment? We have a Second Amendment because we understand in this country that there are some things, inalienable rights.
They are drawing a line between what is regarded as a whole arm and what is only an ostentatious addition to an arm. Illinois is attempting to discredit suppressors by arguing that they don't have the same constitutional protections as arms. Illinois argues that the Second Amendment is about arms, not about these attachments that muffle noise. To sum up, the suppressor freedom lawsuit is a big legal fight in the world that aims to overturn several states' suppressor laws. The lawsuits seek to guarantee our rights are upheld for future generations and to establish a precedent. The Illinois case is a shining illustration of how legal disputes can be utilized to influence the Second Amendment's future and defend the rights of people who uphold the basic freedom to possess and use suppressors without needless limitations. Legal showdown. The legal dispute surrounding suppressors is an example of a typical collision of interpretations. Illinois argues that suppressors are merely accessories for arms, whereas federal regulations recognize them as arms. All types of arms, including contemporary equipment like suppressors, are covered by the Second Amendment, which safeguards the right to bear arms. Illinois is attempting to restrict the case's scope by claiming that suppressors are not real weapons, but lawsuits are resisting this limited perspective. In an attempt to persuade the judge that suppressors don't meet the requirements to be deemed arms covered by the Second Amendment, the Illinois government has adopted a strict stance. They contend that in order for something to be protected by the Constitution, it must be the major event, and suppressors are merely the extras, the supporting cast members who don't require the same degree of protection. They contend that suppressors were not in the minds of the Founding Fathers when they drafted the Second Amendment. However, the opposing side in the legal dispute is singing a different song, contending that the Second Amendment applies to all types of weapons, including cutting-edge devices like suppressors. They contend that just as times change, so do the instruments. Suppressive weapons are included in the right to carry arms. The core of the legal argument between Illinois and the opposing party is the definition dispute.
Those selector switch allow you to have fully automatic, 3-round burst, or semi-automatic.
Got to look at the deadly power these altered guns have and the plea from special agents to get people to stop using them.
Whether they want to run under the radar, or whether they want to alter the firearm, or whether they want to get it registered. It's their choice.
The State House still has to vote on the bill. 9 on your side's Craig Smith looked into how much difference a suppressor makes.
The Supreme Court has refused to change laws that limit access to gun silencers.
Illinois contends that suppressors are only accessories, not the actual Sunday, and thus they do not meet the requirements to be regarded as weapons under the Second Amendment. They contend that this amendment does not apply to these ostentatious add-ons, only to real arms. On the other hand, suppressors are given the green light by federal legislation, which treat them the same as weapons. Illinois' argument is clearly at odds with this federal viewpoint. Illinois is attempting to maintain its position in this legal tug-of-war by arguing that suppressors are merely accessories that should not be given the same safeguards as arms. Federal laws, on the other hand, are strong and treat suppressors on par with other arms. Real-world ramifications arise from this legal conundrum because should Illinois' position be upheld, people's freedom to possess and use these gadgets without needless limitations may be curtailed. In summary, the suppressor legal dispute is a classic case of competing interpretations, with both sides attempting to outwit one another in court. Whether the legal showdown ends with a curtain call or continues to a full production is ultimately up to the judge. Cross-state legal ripples. The legal environment around arm rights has been greatly impacted by recent decisions made by Californian courts in the cases of Miller v. Bonta and Duncan v. Bonta, especially in the Illinois suppressor case. These decisions have been applied as precedent, creating a legal cloud that crosses state boundaries and providing direction for Illinois' campaign against suppressor prohibitions. The legal experts supporting the Illinois suppressor lawsuit are criticizing these California rulings, claiming that Illinois' suppressor limits ought to be struck down if California's limitations were found to be unlawful. These California rulings have had an impact beyond local news. They are now vital ammunition in other campaigns, like the opposition to suppressor restrictions. They act as a model, implying that Illinois' suppressor bans ought to be struck down if California's limitations were found to be unlawful. The legal team overseeing the Illinois suppressor case is using these California rulings as a strong argument and a ray of hope in their opposition to suppressor restrictions. Victories in arm-related lawsuits in various jurisdictions have a profound impact that extends across state lines and ripples throughout the judicial system. A jurisdiction's victory in a Second Amendment case serves as a symbol of optimism for people battling for similar causes in other states, in addition to being a cause for local celebration. These victories are significant because they establish guidelines and establish precedents for future litigants engaged in the larger struggle for constitutional rights.
That is not what the Democrats are attempting to ban today, because that's already banned.
The people on the street that are getting these firearms pointed at them, they're not safe for the people who are using the firearm.
Do arm braces make firearms more powerful?
They do not. They do not.
Reasonable to conclude that gun confiscations facilitated by laws requiring the registration and licensing of firearms
Well, the Arizona Senate has passed a bill to make it easier to own a gun silencer, more accurately called a suppressor.
Gains in various jurisdictions are about creating momentum as much as celebrating successes. They establish a web of legal assistance wherein triumphant arguments and decisions in one domain serve as weapons in other domains. Every victory has a cascading effect, impacting legal frameworks and fortifying the defense of fundamental rights on a larger front. These successes are essential building pieces in the nation's broader mosaic of rights pertaining to arms. They are not isolated victories, but rather interwoven parts that weave together to form a complex web of legal precedents that influence how various countries conceive and interpret their fundamental rights. In conclusion, the legal scene has been greatly impacted by recent decisions made by California courts, especially in the Illinois suppressor case. These decisions have come to represent influence and hope in the struggle for expanded rights in several states. Legal domino effect. The judge in the Illinois suppressor case has welcomed two supplementary authorities from California, Miller v. Bonta and Duncan v. Bonta, into the courtroom, setting up a high-stakes legal drama. These decisions, which have ruled in the past that certain arm control laws are illegal, are now making an appearance in the Illinois case. It's not just a formality. The judge's decision to accept these additional authorities is a game-changer, indicating their importance and potential to affect how the Illinois case turns out. These decisions are being used as convincing evidence, implying that recent successes against specific limits could establish a standard for cases that are similar elsewhere. Their appearance in the courtroom is not merely symbolic. It serves as a ray of hope for Illinoisans opposing suppressor bans, implying that recent successes in other states may tip the odds in their favor. It's like sowing a seed of potential, implying that these rulings may affect the judge's viewpoint and determine how the Illinois lawsuit turns out. Not only a footnote, the addition of these California rulings is a noteworthy development that highlights their potential significance.
Since it offers a strong moral check against the usurpation and arbitrary power of rulers.
Operation of the weapon, which means every time I depress the trigger, a round comes out of the firearm.
An undercover operation and arrested somebody that we thought was probably one of the more prolific suppliers.
The ATF says it still has lots of work to do in order to get these illegal guns off the streets.
Joseph Story, in his commentaries on the Constitution in 1833, quote, "The right of the citizens to keep and bear arms."
It suggests that recent victories against hand-arm restrictions elsewhere may open the door for a similar result in the Illinois case against suppressor bans, thus creating a breadcrumb trail for legal arguments. The addition of these California rulings to the Illinois suppressor lawsuit shows that the courts are open to examining the potential impact of recent victories against arm control laws on the case, which gives advocates of expanded arm rights some hope. If the Illinois lawsuit challenging suppressor bans is successful, it could set off a chain reaction with potentially disastrous repercussions. First of all, the victory may have far-reaching effects beyond Illinois borders. This ruling may serve as a precedent for other cases, stating that, hey, if it worked in Illinois, it could work elsewhere too. Advocates and attorneys in other jurisdictions considering similar suppressor bans may use the Illinois ruling, arguing that it establishes a precedent. It refutes the idea that the Second Amendment does not provide protection for suppressors. This ruling may have a knock-on impact against other restrictive arm laws, strengthening the Second Amendment movement as a whole. This ruling may strengthen the hand of those opposing needless limitations on arm accessories, indicating that the freedom to possess and use suppressors may be stronger than previously believed. ATF's controversial legal maneuver. An important update regarding the ATF and the ongoing litigation involving the pistol brace rule reveals that the ATF is actively seeking to dismiss these lawsuits.
If you were serious, you would acknowledge that 96% of mass public shootings happen in an area where guns are banned.
I think you need to have weapons to take on the government. You need F-15s and maybe some nuclear weapons.
This rule turns law-abiding gun owners into felons is a result of unelected bureaucrats.
Their latest argument for dismissal is based on the claim that the plaintiffs are involved in tax evasion. While this may seem incredulous, it is the stance the ATF is currently taking. They argue that individuals cannot bring forth these types of lawsuits without potentially evading taxes, specifically those required under the National Arms Act. In essence, the ATF asserts that they should be immune to legal action over the pistol brace rule because suing them would allegedly lead the plaintiffs to evade taxes mandated by the NFA. This legal strategy echoes a similar argument employed in a recent ATF case concerning Maiden, Texas oppressors, notably the Paxton Bach case. This particular case revolves around Maiden, Texas oppressors and the existing Texas law seeking to deregulate items such as suppressors and silencers manufactured and retained within the state of Texas. The lower court, utilizing a standing argument akin to the one in the Maiden, Texas suppressor case, dismissed the latter due to a perceived lack of standing.
Seizure of weapons from the homes of law-abiding American citizens.
But at the crux of this is a bureaucrat making a unilateral decision to try to turn millions of Americans into felons.
Gun violence in this country is an epidemic, and it's an international embarrassment.
Now, the ATF is attempting a similar approach, this time in the context of pistol braces. It's worth noting that the ATF recently decided to appeal all pistol brace cases, taking them to the highest level of the judicial system. Tactics in pistol brace rule. The Mock v. Garland case, the FBC case, and the B v. Garland case are some of the key appeals that we have addressed in the past. The B v. Garland case is one of the cases that contributed to the present countrywide injunction against the brace rule. In addition to that, there are further cases, such as the lawsuits filed by Goa and Texas, as well as the SAF and NAGR. In spite of the fact that the ATF had previously been unsuccessful in the case of Mock v. Garland before the Fifth Circuit Court of Appeals, the ATF has decided to appeal the matter once more to the Fifth Circuit in the hopes of obtaining some kind of relief. The ATF is simultaneously attempting to obtain a summary judgment in their favor from a lower court, specifically Judge Reed O'Connor, after having requested these appeals. This is an important development. The purpose of this request for summary judgment is to have the entire pistol brace case dismissed and to have the brace rule continue to be recognized as a legitimate agency action.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
Americans have the fundamental right to keep and bear arms that shall not be infringed.
Getting assault weapons, AR-15s, out of the hands of people who shouldn't have them.
The assertive action taken by the ATF suggests that they are attempting to persuade Judge O'Connor, who has already ruled against them on many occasions, to alter his decisions. A significant point that is offered by the ATF is the assumption that persons who seek to initiate these lawsuits are required to follow a particular process owing to the tax ramifications that are associated with the new rule. Since these lawsuits would result in a statutory infraction and would avoid taxpayers' duty to pay a mandatory tax stamp under the National Arms Act, the United States Attorney for the Federal Trade Commission claims that they are invalid. In essence, the ATF is arguing to the courts that they are exempt from legal action so long as a tax stamp issued by the NFA is affixed to the rule that is being contested. This is similar to an argument that was presented in the past, which was partially successful in the Texas suppressor freedom case. It is because of recent events, notably the Brito versus ATF case, that the ATF feels it is necessary to provide these reasons as quickly as possible. In this particular case, Judge Matthew Kaczmarek ordered a preliminary injunction that completely prohibits the brace rule from being implemented while the lawsuit is still being heard.
Gunned, we're outmanned, we're outstaffed. We do need responsible gun legislation.
We have the third highest gun-related injuries in the country, 90% higher.
Weapons and high-capacity magazines in 3 communities in 3 different states in our nation. Enough!
An earlier decision made by Judge Reed O'Connor in the matter of MSC versus Garland serves as the foundation for this further decision. Furthermore, in the Brito case, Judge Kaczmarek went even farther and granted a countrywide preliminary injunction against the entire pistol brace requirement. This is an important development. After achieving these victories, the ATF made the decision to appeal once again to the Fifth Circuit Court of Appeals, which would result in the consolidation of many cases into a single verdict.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
For God's sake, America already has more guns than people. How many guns do we need until everybody is safe?
Change a law. They are already used to breaking the law, and the people will still do it, will continue to do it.
Additionally, the ATF is attempting to file a move for summary judgment in the lower court before Judge O'Connor, which further complicates the position that they are currently facing. Taxes are at the center of one of the key arguments, with the ATF arguing that the action cannot be filed because the plaintiffs want to prevent the collection of taxes that are required by the NFA. Americans are not permitted to file a lawsuit against the ATF in order to stop the enforcement of the pistol brace regulation or any other rule that is tied to a tax stamp, as stated by the ATF. This is because the Tax Anti-Injunction Act exists. Instead, the ATF contends that individuals are required to go through the process of the NFA, register their brace pistols with the agency, and request a refund if they are unhappy with the amount of tax that they have paid. You are required to submit this request for a refund to the Attorney General, and individuals are only permitted to file a lawsuit for the recovery of the tax payment if the request is denied. Tax arguments. According to the argument presented by the ATF in their brief, the most effective method for a taxpayer to protest a tax assessment is to file a lawsuit for a refund. To be more specific, a manufacturer of arms who is interested in appealing a tax assessment under the NFA is required to pay the tax initially and then submit a claim for a refund or credit. In the event that the claim is denied, the Attorney General is the recipient of the refund or credit. According to the American Taxation and Trade Commission, the plain text of the Tax Anti-Injunction Act prohibits plaintiffs from bringing claims that seek relief to halt the implementation of the National Firearm Association's levy on bracing pistols. Despite the fact that it appears to be ludicrous, this argument is similar to the position that the ATF has recently taken in the Maiden, Texas suppressor case.
There should be an assault weapons ban. I think it would have been up to the Ohio legislature.
Under the new rule, firearm owners will be required to obtain special registration, surrender or destroy their brace.
Ban assault weapons, ban them again, do it now, enough, do something.
As a result of the ATF's argument, plaintiffs are unable to file a lawsuit challenging the NFA tax enforcement on braced pistols. This raises questions regarding standing and jurisdiction. A similar argument was successfully made by the ATF, where the court found in favor of the ATF and dismissed the case for lack of standing. This is a reflection of the argument that was effectively presented. Particularly noteworthy is the fact that the ATF admits within the current brief that the pistol brace rule has many mistakes, some of which might be attributed to accidental oversights. The argument that they are making is that the court ought to disregard these mistakes. As an additional point of interest, the ATF contends that their stance on braced pistols has shifted over the course of the years, and that any previous recommendations ought to be discarded as imperfect. As part of their plan to emphasize their current stance, the ATF is doing this even if it contradicts stances that they have taken in the past.
That men and women in this country have the right to defend their own lives.
A critical and urgent issue, gun violence in America. We're here because gun violence is destroying community.
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
In a number of lower court rulings, most notably those made by Judges O'Connor and Kaczmarek, as well as the review of injunctions by the Fifth Circuit, it is clear that the Assistant Treasury Department is encountering opposition. As a result of the ATF's growing sense of helplessness, they are currently attempting to obtain a summary judgment from the lower court by relying on a theory that was previously successful in the Maiden, Texas suppressor case. Currently, the ATF is utilizing the Texas suppressor case in order to provide a major tax argument in the hopes that the court would be convinced by worries regarding tax avoidance. In spite of the efforts made by the ATF, it is still unclear how Judge O'Connor will react to this argument. Currently, there are a number of injunctions that have been issued, which have prevented the brace regulation from being enforced. The situation, on the other hand, is subject to quick change, particularly in light of the current advancements in the legal system. That's all for this video, folks. We'll see you next time.